EGM Network.
Hi, welcome to Silver Linings. You know me, I'm Janine Barrows, and you know Raul Perez. And today we're going to have a small conversation about the do's, don'ts, and what to avoid in estate planning. For those of you who don't know, Raul is a local attorney with Dill Evans and Rodaback up in Sebastian. And every single day he works with clients on an array of legal issues. And today we get to pick your brain.
Sounds good. Let's get started.
So I have recently encountered individuals who had issues within their family when it came to end-of-life property estate planning. And their loved one had recently engaged in a new relationship, and in that new relationship became further and further away from their bloodline family. And family was pushed to accept that individual and their loved one got married. Were only married about 3 months, and they started having some significant medical issues with their loved one. And the family was trying to get involved to be helpful and supportive to help their loved one throughout. And the new love interest was pushing everybody out. Don't want you to be involved. Only I'm allowed to get the clinical information. Subsequently, their loved one passed during the chaos of all of this. And with the passing came new light that there had been a lot of documentation changes, and the estate and family planning that they thought was set up in a certain way was discovered to not be that way. And light basically insured all assets, liquid, homes, and so forth, were all bequeathed to this new individual who essentially from beginning and the end had only been around about 7 months, 8 months of their loved one's life. And there was a whole lot of distress. And so it kind of brought me to wanting to have this conversation with you today, because in reflection, after they went and met with individuals to talk about what's legal, what isn't, what's fair, what isn't fair, and who was in what right mind, who was giving undue manipulation and so forth, that I came to the reality of it. You can be prepared, or so you think you can be prepared for what may be. But then inevitably, when time passes, you realize there were things you should have done, things you shouldn't have done, and things you probably should have avoided completely. And so today's conversation is exactly about that. That happens a lot more often than people think, doesn't it?
Yes. So at least typically when I talk to my clients, I'll go over, all right, so do you have an estate plan currently? We have not a checklist. We have an estate planning organizer that we use, which we ask your name, your spouse's name, your children, their children. We ask about deceased children, if they have their own children. We go through, we ask who's your CPA, who's your medical doctor, who would you prefer to be in charge of your financings, your health. Give me a list of your assets, whether it be bank, life insurance, homes. Pretty much give me anything you can on this piece of paper so that I can go through it and I can ask very specific questions about some of these assets. So when going through that, I'll talk to my clients and I was like, you don't have an estate plan? That's fine. That's what we're here. We can talk about that and how you want your assets distributed, whether all to one child, equally, all to the spouse, followed by then to your children. We can do all of that. And in particular, most people's goal would be to avoid probate, avoid having that scenario.
Hold that thought before you go further. What is probate?
So probate is the way that we move assets once someone passes away, if it's in their individual name. So if dad dies and he has a home only in his name, not jointly owned with a spouse, we have to go to probate to get that property out of his name. And the same rule applies if there's a bank account, if there's a life insurance, if there's even a car. You normally have to go to probate if there's no listed beneficiary on those assets to transfer them.
Okay. So it may belong to your dad, but because it was only on one person's name, now it has to be legally identified as actually owned by your dad and then put into the rest of his assets, like a pool of all of his assets or their assets.
Right. And there are certain rules, like Homestead has a particular rule to it. But yes, in general, when someone passes away, we have to identify what those assets are, if there are beneficiaries already listed on those assets. If not, we have to go to the probate court to appoint a personal representative in most cases to then find out what those assets are, collect them all, identify who the beneficiaries are, identify if there's any creditors, and then they can go through the process of dealing with that and eventually distributing the assets to who they belong to.
This sounds like something most of us want to avoid.
Yes.
Okay.
And that's what we try to do when we're talking to the client. So
Pre-planning is really important at that, then.
it is. We could avoid every probate issue by just having a 1 to 2 hour conversation and just going through the assets. So maybe clients come in and they say, look, I want to avoid probate. I need a trust. Like, okay, great. I mean, a trust is definitely a way to do that, but it's not the only way to do that. Okay. Sometimes, there are not many assets out there, so we can just discuss a different way of doing things. For example, if you have bank accounts, whether it be a checking account, a savings account, a market only account, Charles Schwab, Edward Jones, whatever account there is, you can list beneficiaries on those accounts, which will do the same thing that you're seeking, which is to avoid probate. So if you have a spouse and you have 2 kids, okay, you talk to the institution, you say, I want my spouse to be my 100% beneficiary after I pass. Normally, those institutions have a second clause, which is a contingent beneficiary, where if the first one passes away before you, those will kick in.
Okay.
And that's basically doing what you wanted to do. It's still avoiding probate. You have to go through the process of identifying yourself to the company, but if everything checks out and everybody was listed as a beneficiary, you're avoiding probate for those assets. When it comes to a house, you can do what's called an enhanced life estate deed. Basically, in that scenario, the person who owns the property will transfer it to themselves for their life, and eventually they will have a remainderment person who will be listed on the deed. So from dad for my life to my son. The benefit is before you pass away, you still have the right to sell it, lease it, rent it, do whatever you want with it. But the moment you pass away, whoever that beneficiary is will be able to record a death certificate, and now it becomes theirs without having to go to probate.
Okay. All right. Which is, from what I would assume, the individual's intention.
Normally, yes. Most people want to avoid probate. I would say 99% of the time. It just takes the court process out. You still have to do things legally. You still have to identify yourself to the bank, and it has to be you. They're not going to give it to anybody else. And a trust, yes, that will definitely avoid probate as well. And in some instances, it is necessary. For example, if there's a second marriage and there's kids from the first marriage, that might be a way where the spouse gets what they're entitled to. And then there's something there for the beneficiaries, the children at the end of the day, or if you wanted to give it to grandchildren, or if there's someone with special needs. So trusts are useful in those type of scenarios where there's a little more planning that needs to be involved, because we're not just giving something outright. We're holding it back for a specific reason to give it to specific people.
Okay. All right. So when we're making estate planning, we are taking into you said assets. So we're like homes, RVs, boats, things like that. Life insurance policies is part of that.
Yes.
401ks, bank accounts, savings accounts. Those are all part of things that we place in trusts. What other things might get placed into a trust?
A home could be placed into a trust. Um, Basically, anything you own could be placed into a trust. And it's basically like putting everything into a company. Okay. You're still the owner. We're just giving it a different name. So instead of being in Raul Perez's name, it'll be Raul Perez Trust or Perez Family Trust. You still have access to it, right? There's no restrictions on you trying to access it. And, what I'm talking about now is what we call a revocable trust. Okay. So those are the trusts we normally do because people want to still have access to their funds, access to whatever they want to do. If they want to, they can undo the whole thing because something happens and now they want to make changes. So it's still you're still doing what you want with all these funds. You're just avoiding an unnecessary part because you're cutting the probate part out of it. And you can go ahead and just administer this trust after the person passes away a lot quicker and most of the times a lot simpler.
Okay. I want you to hold that thought because we're going to come back in a minute. We've got to go to a commercial break, but I want to go back to what you were just saying when we return and kind of loop that and close it in. So hold that thought. We're going to take a quick break and see you in a minute.
My name is Mike Conway, and I'm with Royal Fund Management. We want to revolutionize your workplace retirement system. The recent Secure Act 2.0 legislation has opened the door for pooled employer plans, better known as PEPs. Learn how a PEP can revolutionize your 401k. Call me, Mike Conway, today. I'll give you a free benchmark of your current plan or set up a new plan. Visit secureact2info.com. That's SecureAct, the number 2, info.com.
Investment advisor representative of investment services offered through Royal Fund Management LLC, an SEC registered advisor. 401k maneuvers and other business name for Royal Fund Management.
Blue Dolphin Pools strives to provide quality service with a well-trained staff in the field and in the office. They want you to know that your pool or spa investment means much more to them than just another account. They believe you have entrusted them with your investment, and they'll do their best to see that it stays in top condition. Blue Dolphin Pool has been in business over 35 years, setting them apart from the competition. Residential or commercial, Blue Dolphin will keep you in the swim. 567-5853.
See Painless. We are so grateful for our commercial sponsors and our show sponsors. We couldn't do it without them, and we are super excited about sharing silver linings here in the community and educating one another so that, well, we're prepared for life. So Raul and I were talking before commercial, and we were kind of delving into the realities of what you want to put in your trust and why we want to put it in the trust to protect it, still have access to it. We could alter it if you put your house in a trust, but you need to reset a mortgage. You can still do things like that, but you have to be very specific that it serves the trust and with the end goals, correct?
Correct. So, for example, as I was mentioning, there's not just one way to do things. If I have a client who has a home and a bank account and even a life insurance policy, if the goal is to give it to spouse or to give it to one child or two children or even a grandchildren, niece, whoever, as long as there's no real need for a restraint to give it to them right away, then, we can talk about, well, maybe we just list them as beneficiaries in the bank account on the life insurance and we do an enhanced life estate deed and there's no need for a trust. But if you start telling me, well, here's my scenario, I want my spouse to have everything first, and then I want my children from my first marriage to have everything. Well, how do we get that done, right? Because I can easily say, great, you can list your wife as a beneficiary, and, that's it. But at that point, you give everything to the spouse who has no relation to these kids. She can walk away with it, right? So you need extra planning in that scenario. And this, not to say anything negative about the spouse, but people do weird things. And that's kind of, the reason we plan. Make sure that we don't have that crazy scenario happen. So in a case like that, we can make sure that the spouse is taken care of. She has sufficient assets to, maintain her for the remainder of her life, but make sure that once she passes, we can give everything to the kids. and make sure
Right.
that they have it once the spouse is deceased.
All right. So definitely doing a step by step of desire. What is your end goal with this pot of money, so to
Right.
speak?
And that's the main purpose. If someone tells me, you know, I have a spouse, we've been married for 5 years, 10 years, and if they have kids, and they say, I want it all to go to her, I go through a checklist just to make sure, like, you just want it only to go to your spouse, nothing to your children. You're okay with that? Yes. And you're sure that if she has it and she doesn't give it to, your children at that point, you're okay with that? Yes. Okay. Then that's your wish. I go through the steps, make sure that you understand what can happen, what's not going to happen. If he's okay with that plan, and if that's what he wants, then that's what they want.
So we talk about why we would put a trust in place and kind of what goes into a trust and a little bit of the purpose for extended family and close family and business partners and so forth. Can you tell us what could happen if things are not put into place? Can you give us a scenario of why we want to avoid not being prepared? Why do we want to avoid these scenarios?
So I guess we can start from nothing. If a person doesn't have anything at all they have is their assets, they don't prepare a will. They don't list beneficiaries. At that point, we go to probate and we find out there's a statute that is the intestate statute, which lists who your beneficiaries are by Florida law. We have to go through that list. So I have clients who don't want anything to go to their children. Okay. If you don't do a will at a minimum and say, I want everything to go to X and I want to make sure I don't leave anything to my children, and you pass away without a will, your children are the only one there and you're not married, they get it all. They get it all. No matter if...
So your estranged child, if you don't have a will in place, could come back and take all your assets.
And it's not that they're going to take it. It's rightfully theirs by law. And there's really, nobody can come back and say anything. That's what the law is. I've had clients who have stepchildren. I actually had a case where the person who passed away was married and divorced. The person that was taking care of her at her end of life was her ex-stepson. He was paying for all her care. He had her moved in close by so that he could take care of her. She passed away. And I would imagine the person who would be entitled to it, or probably the most deserving, would be him. But that's not the case. We couldn't give him anything, right? We did a probate and we gave it to 36 other beneficiaries who had no relation with this lady.
Wow.
And that's just because that's the way the law works. So if you don't plan, those are the scenarios. That's the extreme scenario.
Sure.
But the likely scenario is, you have a girlfriend. Some people don't like getting married, right? Some people maintain their significant other for their lives. They're together 30 years. Okay. Now your kid that you have no relationship with, or your brother and sister, or your nieces and nephews who you never thought of giving anything to, that person passes away without any planning, they're the ones that are going to get it. And their significant other, there's no protection for them. A spouse at least has some protections. If you leave everything to a son or daughter and you have a spouse, that spouse at least has some right to go to court and say, okay, look, I have an elective share. I have a homestead that you can fight for. That significant other really has no standing to do anything.
It's kind of scary if somebody spent 30 years together and they have no say in anything, and most likely have invested the monies into those assets themselves.
That in that case, they do have some right to contest what they have contributed, but there's no need for it. There's
but
no
now
need
they have
for
to
it.
get an attorney, and they have to
Yes.
pay court costs, and they have to fight for what
And it's
would
not
have
an easy
been
battle.
their own home environment,
Right.
because that is where they have grown and built with this
Right.
other person. So this is a lot of reasons to be prepared. So can I ask you a question? A lot of people think that going to an attorney is going to cost them $1,000 an hour, and I'm never going to get out of there without. It'll cost me more to do this than it will save me or prevent something. Could you give people a ballpark reality check on that?
I would tell you, if you do the proper planning, it's going to cost you a lot less, and most times significantly less, than having to do a probate and going through that process. I think, you're paying for a service. You can either pay for it beforehand with an estate planning attorney who can do the will, the trust, the deeds, double check with you on your beneficiaries, or you can pay an attorney to do the probate, and hopefully there's not a lot of fighting, because that by itself is going to cost you a lot more than any estate plan, in my experience.
It's kind of like when people go to the doctor when they're not sick, to be sure that they are prepared in the event that they get sick. They should be doing similar things with their local attorney to be prepared, to be preventative in the timely event of their passing, right?
Right.
It's a
And
little, what do they say? An ounce of, what is the little thing about something of prevention? Oh, I'll get to it later. My brain is getting older.
I would recommend you talk to an attorney to do your estate plan. I just recently had a scenario where they contacted us now because they want us to do a deed for them, and I have to go back, and they did their own deed before. Now I got to redo the whole thing.
And you got
So instead of just doing one deed, now I have to put the pieces back together because they made a mistake. So now I have to do 2 or 3 deeds just to correct that one issue where we could have handled it the first time.
the first time. So they were intentionally trying to do something good, but because they didn't have the proper knowledge or the right steps into place, now it has to be done a couple times over to be lined up properly. Well, I have learned some lessons in my life, and I think that most of us need that little reality check and that bump to get our things in order. They are often uncomfortable conversations, but they could be a world of difference for your loved ones later on. And I really think that we deserve the autonomy to make those choices and decisions preemptively. And there's a lot of power involved with sitting down with somebody like you and your team and making plans out that you know are going to be respected and honored when you are no longer in presence. So I just thought that today was a great day to have that conversation and talk about that reality. If they want to reach out to you, Raul, how can they reach out to you and your team?
They can reach out to us at our office. I think there it is on the screen. That's
Yay.
my email directly. And if you have any questions, you can definitely reach out there, and we'll definitely get in touch with you so we can follow up and figure out what's best for you.
I love that. I hope that people do reach out to you and start planning in advance. I myself had to be pushed into that right direction. But once it's off of your plate, it feels really good to know that your choices and decisions are going to be followed through on. Thank you, Raul, for having this open conversation today, you and I in the studio. And I hope that it was fruitful and useful information for our audience. And we will look forward to seeing you next week. Bye.